These provisions here, if you are not careful in reading and understanding them, you will think they run riot each with the other one. For instance, when you look at section 14, section 14 is talking about illegally admissible evidence. We take it discretion to exclude or to admit when an evidence is illegally obtained or improperly obtained. Now, before we look at this provision, the question is, why would the law talk about improperly obtained evidence, illegally obtained evidence? I don't know whether it is in this class that I shared a story of what a lecturer did to me some time ago. When I was a student, I was just going upstairs. I think that was my second year, and the third year students were writing exams. So I was going upstairs to see my aunt. So the man just saw me, and meanwhile, I think he saw me fidgeting with my pocket. As a student, now you always broke, and I wanted to see my aunt to give me money. So the man called and said, "Come here." So I went to him. He said, "What are you carrying?" I said, "I'm not carrying anything." He said, Are you not for the exam?" I said, "No, sir. I'm in second year." He said, "But you are trying to help somebody." I said, "No, sir." So he searched me. So ordinarily, not being the one of the students taking the exam, for me, I didn't think he had the right to search me. So, but after he searched me and then frisking me, I asked me, "Where are you going to?" I told him. He said, "Okay, are you related to her?" I said, "Yes." He said, "Okay, no problem. Don't tell her. Don't tell her what happened." I said, "No, no problem, sir." Because funny enough, he was the tutorial lecturer to my aunt, but he didn't know me. So, in other words, if he had found anything incriminating, that would have done what? Justify the illegal search. Right. So most of the times in law, that happens. You see a situation whereby maybe there are rules. If you want to search my house, you've got to come with search warrant. But all of a sudden, somebody draws from the ceiling into your house. And so, this is where the search. Before you know it, he has brought out the gun where you hid it. So whatever he has done wrong has become what? Legitimized. Because it is in the interest of justice that crime be curbed by all means, even if that evidence is received by improper means. But God help him if in the end nothing is found. That is when they will do what? They pay heavily. It is that principle that is now enshrined in section 14 of evidence. And that reminds me, please, before I leave, what is the deadline for your submission of your files? Project files, what's the deadline? Okay, I'll give you next week. It's something you can just sit down here and even do it. Because what I wanted to do, I wanted to avoid a situation whereby students will just go and copy what has been existing in the library, what people have been writing all over and all over again. Every time somebody's writing all over, the same thing. No. Because of that, I asked my colleagues, map out areas of your course where you want students to contribute. Let's have something new. We just can't be writing the same thing all over and over. Can you listen to me? Can you just listen to me? Right, can you listen to me? So I'm going to propose it again. If by end of this week they fail to do it, then by Tuesday I want to collect what you have. Just do 3 topics. Because the idea is that it's a research. You need to do something new. Not every day land user. Land users in 1978, you're still writing on land users. So you just need to bring in something new on board. So for me, I'm also going to spell out my own areas, lot of evidence, lot of contracts, CLE, and then maybe possibly human rights, so without prejudice to what my seniors will also bring on board if they will do that. So that when you are writing something, we know that we are going to get something a bit new at least, So back to our lecture. Section 14 states, evidence obtained improperly or in contravention of a law. So evidence can be obtained improperly. It can be obtained in contravention of the law. Improperly, if for instance the law says I should not search a lady. As a man, I can't search a lady. And then I now say I'm suspecting this lady that I search the lady and get something incriminating. My search is what? Improper. Do you understand? I have conducted an improper search. But when the law protects somebody, maybe protect somebody's privacy, protect somebody's house, you cannot do this maybe unless you bring a warrant and somebody goes in violating it. That becomes what? Illegal, not improper. So there are two different words, and there is a word of difference between two of them. Improperly obtained evidence and illegally obtained evidence. But what section 14 has done is to do what? Amalgamate both of them in order to do what? Achieve substantial justice. So it says evidence obtained improperly or in contravention of law or in consequence of an impropriety or of a contravention of a law shall be admissible. General rule, admissible. Unless the court is of the opinion that the desirability of admitting the evidence is outweighed by the undesirability of admitting evidence that has been obtained in such a manner. So the general rule is that whether you have conducted yourself improperly and you have brought out a substantial evidence, it is admissible. If you as a police officer or even as a private person, you have broken the law to obtain an evidence that is credible and has weight, it is what? Admissible. But the court has the discretion. The court has the discretion to say, in as much as you have brought this, but the way and manner in which you have brought this is not proper, we will not admit it. Can anybody tell me, give me an example in your own view, where you think that as a judge, you can say, no, I will not admit it, even though you have gotten evidence. But because of the method or the way you obtained it, I will not admit it. Can someone give me an example?
Like a confessional statement, basically
well, if you talk about confessional statement, you see now why we are mentioning section 30. We are coming to that. Confessional statement is a no-go area. Because the rule there is what? Sacrosanct. It's there. Once there's oppressive measure, forget it. That's what the rule has said. So any other thing? Who can give me an example where evidence is before the court, but the court said, by the way you got this evidence, I will not admit it. In order not to waste time, somebody is writing on corroboration. So when she submitted her work, I made her initially when I went to the work, I saw that there was a fundamental misunderstanding of the concept. She didn't quite understand what she was writing on. So after I told her, look, don't write anything. I'm going to privately teach you for 3 days. So after teaching her corroboration, she then understood. And by the time she started writing, now we found ourselves under section 14. Section 14, in terms of agent provocateurs, a policeman that is working undercover, and then you obtain an evidence. Naturally, in the Western world, the world over, even SARS, that's what they do. Most of the time, they work undercover to get evidence. But now, there is a caution. This section is like a caution to it. This section does not, it operates without prejudice to anywhere the provision of the law is strict. No discretion. The discretion here does not apply to where the law has already spelled out what it wants to achieve. But here now, An agent provocateur can come in. For instance, I think I've asked you this question: who has ever watched this film, New Jack City? You know, where this man, Nino Brown, you know, he was one of the foremost drug peddlers in U.S. So his life was reenacted. So he took time. He was always beating the law. He was always beating. So at a particular point in time, somebody, I've forgotten the name of this actor now, acted as agent provocateur, got the information of the drug, everything, went to court, the court of New Jack City, and the court said no. You went there with drug substance. You corrupted them into taking the drug only to arrest them. Are you following me? So it's a different thing that you are there, you witnessed the crime being committed, but that you are the one who incited the crime. The court will say section 14. Do you understand me now? Are you following me?
Yes, sir.
Because of the method you use in eliciting the evidence is such that made them to do what? To commit crime. So that ordinarily, if you hadn't done that, they would not have done what? Committed the crime. So that was how this Nino Brown won the case. So as he was just coming out, somebody had to shoot him. You know, Nino Brown, your soul is required in hell, and that was it. You know, because they felt since the law can't catch you, the bullet can catch you. You know, but the point we're taking home here now is where the law has sanctioned that get this evidence by any means, it will be admissible, but there is an extent to which you cannot go. And that includes that of being what? Corrupting public morals. Do you understand? There's yet another incident where a lady was made to, a policewoman was made to act like an escort. She went into their midst, and because the law was trying to check brothel, operation of brothels, but because she went there and she was just lively about it, and then in the end the court said no, you crossed the line. So section 14 here is talking about what? Crossing the line. If, for instance, the evidence is obtained, the court will do what? Weigh it. How did you obtain this evidence? Is it conscionable or is it unconscionable? If the answer is that the method by which the evidence was obtained is unconscionable, it will become what? Inadmissible. So we now go to section 29 and 30. Now, this is a different scenario. Section 29, 30 have to do what? With what? Confessional statement. And so we are going to see a bit of relationship between this section 29, section 30, and what? Section 14. So we see the relationship now. 29 says, in any proceeding, a confession made by a defendant may be given in evidence against him insofar as it is relevant to any matter initially proceeding. If you stop here, you won't get the fact. You won't get the point. First arm of section 29 says, in a confessional statement, what the person has confessed, so long as the confession is material to the charge he is facing, that evidence becomes what? Material. It becomes what? Admissible. I was like, when I first learned about confessional statement as a student, I asked myself, is there any kind of oppressive measure? That time is voluntariness. Any involuntary measure that will make somebody admit what he did not do. Then I had not been to SARS. Then I had not been to some police stations where they would torture a human being and you'll be crying like an animal. So initially, I'm the academic, I say it's not possible. But when I became a lawyer and I saw that this thing is happening, I said, oh, it's possible. That is why no wonder this place is selling. So one can be made to confess to what he didn't do by oppressive measures. So section 29 is telling us, when once such a confession is made and is relevant to what is charged, it becomes what? Admissible. But look at the proviso. matter in the proceeding and is not excluded by the court in pursuance in this section. Sub 2. If in any proceeding where the prosecution proposes to give in evidence a confession made by a defendant, it is presented to the court that the confession was or may have been obtained by operation blah 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 blah. So despite the good wordings of section 29(1), all you need to do is to do what? Bring in the issue of operation. And the whole thing comes falling like a pack of cards. So that's what section 29 is talking about. So it is a way long different from the provisions of section 14. So we finally look at section 30, which has tried to, guard itself like section 14. And it says, where information is received from a person who is accused of an offense, whether such a person is in custody or not. So this may not necessarily be, in quotes, confessional statement as we look at it. And as a consequence of such information, in fact, is discovered, the discovery of the fact, together with evidence that such discovery was made in consequence of the information received from the defendant, may be given in evidence where such information itself will not be admissible. Now, what this provision is saying is that if the defendant makes a statement and following the statement an investigation is carried out and it is discovered that there is an evidence which points to the fact that he might have committed the crime, then the court will do what? Will rely on it, even that if that information is done what? Obtained improperly. So he's trying to marry himself with section 14. But what is the difference here? Look at the word may. It may be given in evidence, which means the court is also still bound to do what? Scrutinize the process by which the information is gotten. Somebody cannot just, naturally, even if a person is a criminal and he's caught, he can't tell you, maybe he's not caught red-handed, he just invited him. I understand you are the one who stole the money. Naturally the person will do what? We deny. You understand? Maybe when the person all of a sudden there is he sees stars in his eyes and then he just say wait let me tell the truth. So the first one wasn't the truth, right? So under such a situation the court will scrutinize it, but the stronger thing here is that the discretion here is the person has said okay, what was stolen was kept under so place at so place. What was stolen, and then police said okay, no problem, confessional statement. Once you make any positive statement, it's confessional, but that's not what it is. So maybe they go there and discover the bag of money. Now when you take that bag of money, remember that you have compelled this person to make that pronouncement and to tell you where the money is kept. It only goes to show what? That he has knowledge that something was stolen and that it was there. So you're going to look for corroborative evidence. You can't stop there. That is the main there. The judge will have to scrutinize it. The same as section 14. How was this evidence obtained? Now, the fact that he said that money was kept there, he has not said I stole the money and that it was kept there. You understand? But that evidence can do what? Give clue to the court. But in practice, when such a thing is the case, the court weighs the evidence. If the evidence is such that has deeply implicated the defendant, the court will do what? Admit it. And will do what? Act upon that very evidence. So far so good. I take your question. So I will enjoy you to read section 83 of the Evidence Act. That's for the whole class. I will teach that one, for the whole class. Section 83, where we still go ahead to look at the other assignment that are still pending.
Something I also understand clearly is, for what we talked about, if there is any offensive method, you should pay the professional statement, right? So it's going to be inadmissible. But then, what you were saying was see that there shouldn't be any oppressive like threats and all that. But then I don't really understand it.
Look at, okay, take your time and read. You know, normally what age is that after lecture? Take your time, go and read it again. Do you understand? When you read it, you see that section 14 is different from section 30. But they have a little relationship. Section 30 is totally different from section 28 and 29. Do you understand? That talks about what? Oppressive measures. So when you read it and read in between the lines, you understand it. Any further question? Any further question? All right.